A very good afternoon to all the viewers on this virtual platform. I, Dr. Rajesh Kumar Singh, Associate Professor, Parul University, Parul Institute of Law. I warm welcome Advocate on Record, Pallavi Pratap Madam, on this virtual platform. And I am very much thankful to ma'am because she has given a very precious time as per the already she has lots of matter in the Supreme Court, but still she has given us a time, and this is the second time which I have invited and she has accepted my invitation. So I am thankful to you, madam, on the behalf of Parul Institute of Law, Parul Institute. Let us speak about ma'am. First of all, Pallavi Pratap madam focuses on the litigation part, and she was chosen as a 40 under 40 lawyers and the legal influence by BW Business World magazine. She has over a decade of experience and regularly appears before the Honorable Supreme Court, High Court, National Company Law Tribunal, Consumer Commissions, National Green Tribunals, and various arbitration. She is an MBA in Finance from LA Trobo University, Melbourne, Australia, and brings her a unique understanding of the corporate law and mergers and acquisition, being a former investment banker. She has actively involved in the cases pertaining to the company law, insolvency and bankruptcy code, white collar crimes, criminal matters, family matters, etc. First of all, I am thankful to ma'am on this platform. And secondly, the topic of this webinar is this is a series on the drafting and pleading. And madam is going to elaborate that how to draft a matter in various courts pertaining to the bail application. And this is a very important topic to all the students, and not only to the students, to the advocate who are practicing in the courts. This is important to all the viewers. So, not wasting more time, madam, I am handing this session to you, ma'am.
Thank you so much, Dr. Rajesh. I hope I'm audible.
Yes, ma'am.
All right. Thank you so much for inviting me again. And it's such a pleasure to actually interact with all of you. Especially, I hope these sessions are useful for all the young lawyers who are there, and also lawyers in making from Parul University. I'm sure all of them must be very occupied with studies just now. The topic that has been given to me is very interesting, drafting of bail application. And I have a small presentation that I would want to run you all through it. But before I start, I wanted to just give a little overview in terms of, a couple of things that I have personally felt is very useful. And one of those things is this book, which is called as Taking Bail Seriously. This is a very recent book which had come, and this is available from LexisNexis. It's written, there are a compilation of articles which are written in this. It includes articles by Salman Khurshid sir, Siddharth Luthra sir. Everybody knows that he is one of the leading criminal lawyers. And then there are other legal luminaries who have written in this book. And I have for once, realized that this book, if you are able to read through it, you will realize the entire, the bail jurisprudence in a very effective manner. So there are quite a few, articles which are here. These are basically, if you would look, I don't know if I'm able to show it to you over here or not, but there are primarily, articles on specific points. So for instance, if you would just pick up any of these articles, the first one being my favorite, which is by Abhishek Manu Singhvi sir. And Dr. Singhvi has written in this about, the need for urgent and comprehensive revamp as far as bail jurisprudence is concerned. Now, I'll just give you a little backdrop about how this book had actually come about. If you would all remember, there was a case of bail of Mr. Chidambaram, which was going on. And if all of you would remember how it was, jumping between the Sessions Court and then at the High Court, then it reached Supreme Court, and multiple bail applications were filed, and how a lot of times voices were raised as far as bail jurisprudence was concerned. And it was around the same time that this book came, and it talks about very comprehensively on all aspects of bail. So if all of you can, if you're looking at practicing on the criminal side, I suggest that this book will be really useful, not just because it gives you an understanding about bail jurisprudence, but also it has encapsulated these very interesting case laws on specific topics. And these case laws, then it becomes very easier for you to use these case laws when you are drafting your bail application. So for me, I found this to be a very good book, so I thought that I'll recommend it to everybody. It is not that I'm getting paid to talk about this book. It's just that it is a brilliant book, and I really liked it. Especially the chapter on anticipatory bail, I feel, is a very, very well written chapter. It is called as Anticipatory Bail Evolution, Philosophy and Unceasingly Shifting Juridical Discernment. Then there is also another chapter which I think has started to take prominence now, which we will not be able to talk so much about because it's an hour-long session, but something which is called as transit bail. You would be hearing about transit bail very often, but not many people know exactly what a transit bail is. If you would have followed, there was an encounter which had happened in Kanpur of a gangster. But before that, he was there in Ujjain, and from there he was to come over to Kanpur, and ideally a transit bail should have been applied for, but they had not really done that, and in the meantime, police had gone and arrested him from there. But we are seeing increasingly that if there is an accused person who is out of the jurisdiction of, let's say, an X area, then transit bail is something that you can apply for, and that basically gives you a bail in terms of when you are reaching from an X person to the area or jurisdiction where a crime was committed and an FIR was lodged against you. So you would love to have this book, and I hope it will really help you all. Now, coming to the drafting of bail application, I will just start sharing my screen. 1 second. Okay, 1 second. I think there is some problem that I'm facing. May I just send it to you, Dr. Rajesh, if you can maybe just put it on. I think there is some problem that I'm facing over here. I'm just forwarding it to you. In the meantime, I'll just start with what I need to say about it. And you can, so you are not audible.
You just mail me because my mail ID is there now. So you just mail so that it is
perfect. Yes. No problem. I'll do that. But in the meantime, I also want to, take all of you through about, the nuances of bail application. It is not that, drafting is a very difficult thing. I think all of you have also been seeing, last 4 sessions have been all about drafting. So I think you all understand exactly what a drafting would be, if there is a general drafting that you have to do. So what is so different about drafting a bail application? I mean, if I ask myself, what is it that we have to primarily keep in our mind when we are looking at drafting? Now, for me, I have always realized that, when you are applying for a bail application, you're basically looking at someone who has, in most likelihood is a person who is innocent until proven guilty. So if you're looking at filing an anticipatory bail, or if you're looking at filing a regular bail, would you what is the reason, or what is it that we want as lawyers to for our client who has been accused. We want that that person should be given an opportunity to at least be out in the society to earn a livelihood, etc., till such time that he is proven guilty. Anticipatory bail provisions, I'm sure you all understand, is primarily to ensure that if there are cases, and I'm sure you all would be seeing, I'm sure a lot of lawyers would be seeing that 498A cases are there, where so many times a person is wrongly implicated, and one would want to have an anticipatory bail. Now, one of the most important things to notice is that as far as anticipatory bail is concerned, you have to see whether or not a particular state has anticipatory bail provisions or not, because a lot of states had done away with it. But now, for instance, Uttar Pradesh, Uttarakhand, they've all started with anticipatory bail provisions. For the longest time, it was not there. Rajesh sir, I've just emailed it to you. If you would see it. It is on rajesh.singh90549 @Parul University. Just emailed it to you. So coming back to the different provisions, let me just take you through what are the different provisions under which a bail application can be filed. But before that, let's understand what is bail. So now bail originated from a French verb which is called as bailer, which means to give. So if I'm supposed to, if somebody is has done something wrong, a bail is given to that person in exchange of a surety from people who are, members of reputed members of society, in order for a person to be released from the jail, that is. Or if they are not jailed, then it is primarily to secure provisional release of a person who is accused in a criminal matter where judgment is yet to be pronounced. So this is primarily where bail, if we look at a definition, it will be there. Now, bail is a liberty to the accused to remain at large till the investigation, inquiry, and trial is over. A lot of times we see that, we have people who are, especially in India, who are accused of wrongful acts. So giving a bail primarily is, or getting a bail primarily is because you want that the accused person who is, to be presumed as innocent until proven guilty is, the liberty is granted to him to be out on bail so that he can take care of his livelihood and to take care of his family. If so many times we see that there are wrongful accusations which are put on people. Now, the courts system in India is extremely, extremely, wary of bail in terms of anticipatory bail, if we look at. Why is an anticipatory bail not given so often? Why is it that an anticipatory bail is very difficult to get? And that is because the courts always come with a mindset that if there is an anticipatory bail that needs to be given, that has to be given only when we feel that a need, that the accusations are such which are completely on the face of it not proven.
Madam, I have uploaded, so can I present? When you tell, I will present.
Please get started, sir. Please, I'll be very grateful.
Just a minute. Just a minute, ma'am.
Sure, sir.
Yes. Shall I zoom it out?
So you can start with, this is perfect. So if you can go on the next slide, please. I'm also sending you an FIR copy, okay, which I will require after my presentation is over, just to keep, just to give an overview. So should we start then?
Yes, ma'am.
I've sent you the FIR also, so please have it handy, sir. So I've just covered the introduction in the first 2 points. I'm going to the next point, which is about although the court has discretionary power over the grant of bail, the accused has a right under Constitution of India, especially Article 21 of his life and personal liberty, as hence the accused has a right to seek bail in order to get himself released unless found guilty. This is the part that I've covered already. So can we move on to the next slide, please?
Yes.
Now, state of Rajasthan versus Balchand is cited most often. I think in every bail application, you will see this line coming in that the basic rule of criminal justice system is bail and not jail. And this is also, if you would see, especially during the COVID period, we saw that, a lot of accused persons or under trials were given interim bail because of they wanted to not have the jails completely occupied with people people were scared that that COVID might spread and it will be very difficult. So that was also an interim bail which was provided. These are different kinds of bails that I'm talking about here. Now, any adult person who is a close relative or a known person of the accused can be a surety. The person acting as a surety needs to have a title on any immovable property. Typically, we see that people would put in their FDs or some kind of a security as a surety, and that person should not be an accused person in any other offense. That is also an important point to note over here. So next slide, please. So now let's look at types of bails. When we're talking about different types of bails, we are looking at basically bail in bailable offences, which is section 436, then bail in non-bailable offences, which is section 437, and then anticipatory bail provisions, which comes under section 438. Now, these are very easily defined you would see it all defined as far as CRPC is concerned, and it is very easy for anyone to understand the provisions. Primarily, you will see that 437 or 438 is where you use your bail applications are typically drafted under these two. So next slide, please, sir. Now, I'll very quickly take you through the bailable. I'm sure every one of you would understand it, but just for people who probably are from the first year or second year and have not read CRPC so far, Section 2A of CRPC defines bailable offences as offences which are shown as bailable under the first schedule or which are bailable by any other law, and non-bailable offences are those offences which are not mentioned in the first schedule. Now, general reading of the first schedule indicates that by and large, not so serious offences you will see are made as bailable offences, whereas the serious offences, you're looking at 376, you're looking at 498A, you're looking at the dacoity, robbery, all of these have been under as a non-bailable offence. Now, as per the first schedule, offences under any law other than IPC which are punishable with imprisonment of 3 years or more are considered as non-bailable, and offences where imprisonment is less than 3 years are considered as bailable. Now, some other time we will also have a discussion on what is a compoundable offence and what is a non-compoundable offence. So next slide, please. Now, let's look at bail in bailable offences, which is 436. Bail is the right of the person if he has allegedly committed an offence which is bailable in nature. So typically, Section 436 imposes an obligatory duty on the police officer or court to grant bail to a person alleged to have committed a crime which is bailable in nature. Like we just talked about, anything which is under 3 years. Now, the section further also makes it clear that it is the duty of the police officer to release the accused on his personal bond in spite of the order of surety if he fails to produce the surety within 7 days. And this is primarily from the perspective that it is possible that a person may be poor or he may be indigent, indigent meaning that he's completely bankrupt and that he's not able to arrange for a surety. And therefore, he has to be released on bail. So next slide, please. Now, coming to section 437, these are non-bailable offences, and because they are non-bailable offences, they are the ones where it is very difficult to get bail. Also, the more heinous a crime, the more difficult it is for a person to get out on bail. And this is why you will see that so many times a bail matter will actually travel all the way to Supreme Court, and so many times you will see that bail is granted from Supreme Court. Like, for instance, I did a matter very recently where there was a 498A FIR which was lodged against this person, and even though he was already on bail from the High Court, because of his non-appearance on a given date, the bail got cancelled, and then the bail which was already given to him got cancelled, and then he had to come all the way to Supreme Court in order to get a bail from Supreme Court. So there are so many instances where you see that a bail is not granted by Sessions Court, especially anticipatory bail. I think anticipatory bail, you would realize that it is very difficult to get a bail from the lower court, looking at the nature of the crime. Now, as far as regular bail is concerned, you will see that typically what the courts actually follow is that in a regular bail, you would see that courts look at the number of, what is the time that you've already spent in the jail as far as the crime is concerned. So let's say, for instance, if there was a 7-year thing and you've already put in some 2.5, 3 years in the jail, then the court will come with a compassionate view and then give you, a regular bail. But this is not a rule of thumb thing. It is just that one notices that something like this typically happens. Now, coming back to section 437, if a person is accused of committing a non-bailable offence, he's arrested or detained by a police officer without a warrant or appears before a court other than High Court or Court of Session, he may not be released on bail if, 1, there is a ground to believe that he is guilty of an offence punishable with death or life imprisonment, and secondly, if he has been previously convicted of an offence. So a lot of times you would see that, the history sheet of an accused person is also noticed. So next slide, please. Now, he may be released if he is a person who is under 16 years of age or is a woman or is sick or infirm. But believe me, sickness is not something that you would typically get a bail on for the or being a woman also, because it is not that women do not commit crime, and they do. So the bail application can be denied because the judge, especially the sessions judge, will actually go into the entire realm of FIR, will look at it, and then only take a decision of whether or not to give you a bail. Now, court upon its satisfaction may release the person if it is fit and proper to do so. And if the police officer at any stage of investigation believes that there is no sufficient ground for non-bailable offence or further investigation is required subject to the provisions of section 446, then he may be released on bail bond without sureties. This also happens, but very rarely. Very rarely. I mean, I think I've basically not seen any such case so far. If at any stage of trial, court is of the opinion that accused is not guilty of such offence, then it may release him on bail without sureties. This I've seen happening. The next slide, please.
Next slide. Hello.
Next slide, please. Now, coming to anticipatory bail. Anticipatory bail provision is something that I've been wanting to see, because you would find that most of the time you would be applying for an anticipatory bail provision. Now, there is always a thought, and this is something that I also wanted to discuss here. You would see that I'm not really going so much into drafting just now, but I'm giving you a experience of what I have. A lot of times the client will come to you and you will be told that, madam, anticipatory bail we will not apply, because if I apply for an anticipatory bail, that means that I am guilty of the crime, and that is why I am applying for an anticipatory bail. You will see this happen so many times that a person will come to you and say this. But actually, I personally have always felt that if you know that there is some wrong accusation which is against you, and you have, cogent evidence to show that prima facie there is no case which is made against you, then anticipatory bail is always a better option. For instance, a lot of times what happens is when a matter travels to, let's say, in appeal, if an anticipatory bail has been rejected, then as an arguing counsel, when you file for a bail application, you must ask if, let's say, for instance, your bail application in an appeal is getting dismissed, then you must ask the honorable judges that if they can grant you the liberty that the day you file your bail application, it gets heard immediately, and that on the merit it can be decided. The regular bail application here, because this is just a practical aspect that I'm telling you, because I feel that a lot of times judges are inclined to give you that liberty that you can approach for regular bail immediately, and that the same can be that at the time of filing itself when you're surrendering, and then at that instance only it is decided on the basis of merit. Now moving on. If you get an anticipatory bail is granted by the High Court or Court of Session. Now, there is again another debate that happens a lot. A lot of times people will go directly to the High Court and file an anticipatory bail. Now, the problem here is that even though it is, Section 438 is completely silent on which is the right forum where you should go to file your anticipatory bail. And a lot of times people skip their court of session and go directly to the High Court in order to get themselves a bail. But in my experience, what I've seen is a lot of times High Court would then say, why is it that you skipped the session? You should have gone to the session court and got it over there instead of coming directly to us. So it is always advisable to actually go to the court of session and then exercise your remedy over there and then go in an appeal in case it gets rejected. This is just a word of caution that I'm giving, because as it is when you are applying for an anticipatory bail, there is not too much time between the bail application being heard and the time that you are supposed to be joining up investigation. Now, the second important the citation that has been given here is State of Assam versus R.K. Krishna, where an opportunity of hearing to the opposite party is must before granting anticipatory bail, and that is why it is important when you are filing your bail application, please ensure that an advance copy is always served to the other side. Otherwise, inherently extra time has to be killed because the advance copy is not served, or the PP is not appearing, or the government counsel is not appearing. It's important that you ensure that advance copies are served and that the IO is there with the case diary and things like that. So this is more of a management that as a lawyer sometimes we have to do. If we are looking at anticipatory bail immediately. Now, court, while granting following factors into consideration: nature and gravity of the accusation, antecedents of the applicant, including the fact as to whether he had previously undergone imprisonment on conviction by a court in respect of any cognizable offense or not. So, these are 2 points of it. So, can you go to the next slide, please? Now, possibility of the applicant to flee from justice, and this is one of the reasons where you would see that the court will normally deny an anticipatory bail, because they would feel that maybe you are at a flight risk, that you might just flee away and that it will be very difficult to grab hold of you again. And also where accusation has been made with the object of injuring or humiliating the applicant by having him arrested. So many times you would see, like I said, 498 cases where a bail application is filed. In so many times we've seen that it is only to humiliate a person. Then in those provisions also anticipatory bail is easily granted. Now coming to section 438(2), that prescribes the conditions for granting of the anticipatory bail. One, that the person shall be available for investigation as and when required. Two, the person shall not make any threat, inducement, or promise to any witness. This is the only reason why typically a bail is denied, because they see that, if they get bail, then the witnesses can be tampered or the evidence can be tampered. As a result of this, whenever you're drafting your bail application, make sure that you're putting in these points where you show that this person will not be, tampering with evidence or witness, or he undertakes and things like that. The second important thing is that we need to look into is also that when we're talking about witness tampering or evidence tampering, for instance, we have to ensure, so many times when let's say you are filing a regular bail, and you are arguing this case before the honorable High Court or the Supreme Court, then you have to know, these are important things that I've seen a lot of times lawyers actually miss out on. But you have to know what is the stage of the trial. You may be arguing your bail application and you have absolutely no idea about what is happening, what is the stage of trial as far as the trial is concerned in the court. So you need to know how many witnesses have been examined, how many have been cross-examined, what is the stage of the trial, because then the judge will ask you, and the judges always ask you from the perspective that is there a possibility that you may tamper with the witness or the evidence. So then it is important that you are arguing, you know what is happening. Always make a statement that, okay, XYZ or the more important witnesses have been already examined. So the judge will then be kind enough to give you a bail, because looking at the fact that you will not be tampering with the witnesses. Now coming to the part, which is that the person shall not leave India without the permission of the court. So many times they also say that you will not be leaving the jurisdiction of the High Court, or if there is a custody battle which is going on, then you will not be taking the child away from the jurisdiction of the High Court or a specific court. These things you will see that these are all conditional bails which are given. These conditions are imposed and that condition is given. Now, coming to the drafting of bail application, even though those pointers I had given primarily for you to understand, for a bail application to be drafted, you will find hundreds of formats which are available. You will find hundreds of formats for your lower court, you'll find hundreds of formats for your High Court, you'll find hundreds of formats for your Supreme Court. But what is it which is most important when you are drafting a bail application? The biggest and the most important thing is your ability to read an FIR, because it is there where you can show the lacunas which have been there as far as FIR registration is concerned. It is on the basis of FIR that you have to annex it. Two, you have to show how the case is not made out. So many times you'll see that maybe an FIR was filed after a delay. Maybe the incident took place on an X date and the FIR gets filed after a month. So that shows an intention that probably the delay was there because it was filed as an afterthought. That makes your case strong. For instance, you will see that in FIR, something else is said, and then under 161 statement, you will see that there is a discrepancy. Now those discrepancies can be used in your bail application to get yourself a bail, because then you will show that FIR may XYZ was written, but whereas when you look at the statement of the complainant in 161, you will see that ABC and XYZ was written. So that is basically an improvement. So you bring about that improvement and you show that in your bail application that there is an improvement which has happened. Now, these are subject to whether you're applying for a regular bail or you're applying for an anticipatory bail. You can understand the documents which are available to you at an X point in time. Now, FIR reading is also very important, because you also need to know that when, let's say, an FIR is written, who is the complainant? What was complainant's role as far as the an incident was concerned? Whether you have an alibi to prove. Sometimes we've seen that bail applications are accepted only because you have an alibi. Now, one would say that in India the plea of alibi doesn't work, but it definitely works. Let's say I was in Ahmedabad, for instance, and some incident took place in Delhi that day, how is it that you will show my physical presence on an X place if I was actually available in some other city? So plea of alibi definitely works. You just have to make sure that you are able to use that. Also, if there are material that you have, for instance, these days WhatsApp messages, email messages, etc. So many of these things are there, or phone call records are there. These are prima facie evidences that you have to put in your bail application when you are applying for it. Making the best case forward. Also, always remember that when you are making a bail application, when you are drafting a bail application, it is pertinent that that your narrative remains the same. A lot of times I've seen that someone has said XYZ in their bail application, whereas when it goes on trial or when they're giving a statement, completely differs. So it is important that the narrative is at least the same. Don't make out a narrative, be honest, but at least know your honesty correctly. That is something that I felt was important. As lawyers, sometimes we become too defensive. I think being a defensive person, as far as drafting a bail application is concerned, is not a very good thing. Sir, can we go on the next slide, please? I think we should skip to the place where the bail application is. So if you can just move forward, sir. Yeah, so this is the contents of the bail application, which you will see primarily as far as anywhere it is concerned. Be it if you're going for an anticipatory bail, you're going for a regular bail, or if you are applying directly in the High Court, then, or if you're going in an appeal in SLP, then also these are the important things that you should know. Now, name of the magistrate court is something which is important. Whosoever if it is before sessions, then the sessions court name of the parties. This is important. You should know. A lot of times we do not make the complainant a party. We will always say that no, the complainant should be present when I'm deciding a bail application. So it is always advised that you make the complainant also a party and not just the prosecution state. Now, sections under which of CRPC under which the bail application is moved, here we mean 437, 438, or 436. FIR number. This is very important. You should know the FIR number. You should know the name of the police station, date on which, if the accused is already in custody, if it's not an anticipatory bail, then date on which the accused was taken into custody. And then we come to the most important part, which is the grounds on which the bail should be granted. I've just talked about it at length, but when you're drafting a bail application, the grounds more or less remain the same. But how you bring those grounds pertaining to one FIR, because everything differs from case to case. So one FIR will be very different from another FIR, and it is very important that you understand the entire incident correctly. A bail application becomes a very important application also, because sometimes when your first bail application is denied, you will be filing another one. But then you have to annex your first bail application with that second bail application that you will be moving. If there is a change in narrative, believe me, the judges can just see through it. So don't go ahead and change the narrative. You can apply for a second bail application when there is a change in circumstance. Change in circumstance does not mean change in narrative. Your narrative will always be the same because it is the same thing. The incident must have worked in a clockwork manner, and you have to bring that out in your bail application. But when it comes to, for instance, talking about second bail application, when we're talking about change in circumstance, what is a change in circumstance? Now, a change in circumstance could be a material evidence which is found. For instance, you have a murder case which is there, and for instance, the murder weapon is found on behest of, let's say, a co-accused, or murder weapon is found from another person who is not even involved, who's not even named in the FIR. So that is a change in circumstance on the basis of which you can file your second bail application if the first bail application has been dismissed. These are important points I'm telling you from the perspective of practically how we use it. That is one. Secondly, you will often see that there are chances where you will have to file as many as 3 or 4 bail applications in order for your accused person to get out of the jail. So these things actually happen, and therefore every single bail application and every single drafting of a bail application becomes very important. You will also see that in lower courts. I have seen it so many times in lower courts, and especially in smaller cities. I've seen where a 2-page bail application with the same ground is. It's as if they've just photocopied and changed the name of the person and the FIR number, and that's all that they do. And then the same thing gets filed all the time. If you are, sometimes maybe if you are in anything like that, please don't, because anybody who's come to you has come to you with the, with a lot of trust. So it is important that you don't just photocopy a bail application or cut paste a bail application and just file it across. Now, the other important thing is that surety of the accused not absconding if the bail is granted. This is a line that you also write in this para that you use, that I undertake that there will be the accused person will not be fleeing, and accused will always be present before the court in every single hearing that will take place. So you may ask me that sometimes when there is a possibility that the person cannot be present, you have to move an exemption application if the accused person is not able to join the investigation. Now, then, of course, you have to also give an undertaking that you will not leave the country without the permission of the court. And so many times, the passport, gets is taken by the court, and you can then file a second application in case you have to go out. Then you will have to file another application in order to get your passport back. Now, then finally, we come to prayer. Prayer here would be different depending upon the form. So, for instance, if we are looking at the lower court, it will be a very simple prayer that bail may be granted subject to the conditions and in such and such FIR number, etc. But if you are, let's say, for instance, coming in Supreme Court for a regular bail, then you can obviously ask for an interim relief, where you can ask for an interim bail subject to the regular bail being given. So that interim bail will be for a specific time period that the court may, upon its discretion, decide. So next slide, please. Now this is a typical sample of a bail application that you will see. This is pertaining to that of Delhi. This is the typical cause title that you will see. FIR number will be there, police station will be there, the sections will be mentioned, date of hearing, etc. will be given. Please. This is where you will see, the points which are there. Especially if a person is arrested, then you will give what is the date since when the accused person is confined in jail. Now, here I would like to add that if you are coming to Supreme Court or finding a bail application here, then you have to give a certificate, where the jailer will put in the number of days that you have been in the jail for. So there is a jail certificate that basically, a certificate that comes from the jailer, where it very clearly says that, okay, this is the number of days that you've been behind bars. Now, this is primarily, the pointers we will be using. I can share this application later on also, but this is how it is. You will find a lot of different kind of formats. You can use the way you want. I mean, you can write it down the way you want, as long as you're making sense and as long as you're putting in the points that are relevant for the case. Do not do a cut copy paste job, because every bail application, like I said, every crime is different, every FIR is different, and therefore every application. Can you go to the next slide, please? Now, this is just an instance of the application that we are looking at, that no purpose would be served by keeping the applicant or accused behind the bar as police has completed its investigation and filed a charge sheet, if the charge sheet has been filed. If the charge sheet has not been filed, then there are different other remedies under which you can apply for bail application. So, for instance, you see over here that in this case, the co-accused people who already granted bail. So this is also something that is important for you to notice, that if there are co-accused people in let's say a given case, then if they have been granted bail, then you should mention it in your bail application, because on parity you can get a bail. Often you will see that co-accused typically get bail easily. Whosoever is a main accused would find it hard to get a bail. Then antecedents, of course, the criminal antecedents of a person who's asking for bail is also seen. I remember when I was, I was working for state of Uttar Pradesh. I remember there was a person who had applied for bail and we were opposing it. We were for the government. So, I remember that I had asked the police officer to get me the history sheet, and there were some 88 cases against that person. And therefore, of course, his bail got denied, because he was a history sheeter and he had so many matters, so many FIRs which were lodged against him. And there was not even one single main, section which was not against him. Everything was against him. 376, 302, 307, all of these major cases, they were already against him. And so next slide, please. So this is how it typically is. You would see here that the prayer is written in a single line. But if you are, let's say, before the High Court, then the prayer changes to, like we have it. There will be two prayers, and you can also ask for an interim relief if subject to, the conditions which are being imposed upon you. And then moving on, so I think this should be the last slide.
Yes.
Right? You can open up the FIR that I've sent you, sir.
Just a minute. You have sent that FIR also?
Yes, sir. I emailed it to you. Kindly check.
In the same slide?
I've sent it to you again, sir. It's a second email that I've sent you.
Just a minute. Yes.
I just want to take everybody through the FIR and basic contents of it, because these are students who want to know the different contents of FIR. And how to read an FIR, because if you're going, FIR is a document which can actually confuse you a lot as well. So I just thought that it's best that I talk about little bit about the FIR also. So typically the format of FIR you'll see is the same across the country. It is not that it varies. It is because it is the same 154 CRPC provision. But you would see that, the language sometimes may be different. So maybe in Calcutta, you'll find it written in Bengali, especially in Maharashtra and Bombay, you'll see it always in Marathi. So you have to get those documents translated. But most of the places you will see, like for instance, in Delhi, you'll see it in English, or in Hindi, in UP, you will see it in different languages. Now coming to basically how it looks like, the first one that you would see is the district that is there, and then FIR number will be there, and the date of registration of FIR will be there. This is the most important thing for all of us to remember, as to what is the date given as far as FIR is concerned. Then which are the acts and sections which have been used. This is also important because sometimes there will be multiple acts. So for instance, there could be Arms Act along with the IPC provisions, etc. Here, so for instance, they've used IPC and POCSO as well. Coming to the next point, it will be about occurrence of offense. You will see that they will give you an information as far as at what time the information was received and at what time the general diary entry was made. So many times you will see that the general diary entry number is not given, but you will always see that what was the time at which the information was received. You will also see that whether type of information was written or oral. So many times a person is giving an oral information, and the head constable who's posted in a particular police station will be writing it down. So this is, a lot of times you will see that ROAC is written, which basically means that this is being read over and clarified before the the complainant who's there, so that he understands what has been written. So, and then you will also see place of occurrence here. Place of occurrence means that exactly where a typical crime took place. A lot of times you will see that place of occurrence becomes very important. I mean, I remember when we were practicing as the government counsel, we would also see that many a times a person would get a bail only because the complainant would say that the incident took place at an X time, and we would see that for a person to reach from the place of occurrence to, let's say, the police station would have taken, let's say 10-15 minutes, but he reaches there after 5 hours or 10 hours, and the incident, you can always make out through postmortem, etc., as to what time the incident may have taken place. So you can then justify your delay in filing of an FIR by those specific pointers that you can see. You can also look at place of occurrence to also see, if let's say the complainant was actually present at the place of occurrence or not. So therefore, was he an eyewitness, or did he witness the incident, or how did he get to know, and when is it that he reached the place of occurrence? These are the ways that you can build up your argument, especially when you're doing a bail application prima facie. Then, of course, the complainant's or the informant's name comes in here. Sometimes it could be the victim themselves, and sometimes it could be someone from the family who may have registered an FIR. Now, this also becomes an important part, because if the victim himself or herself has stated in the FIR, then it is more potent. But when you are looking at somebody else from the family writing it down, then there are chances of discrepancies coming in. Then details of known suspects. So you will see a lot of times, that they will name the suspects in the FIR, that I suspect that these are the people who may have committed this crime. But a lot of times you would see that Agyat Vyakti is written. That is, the unknown persons have committed this crime and we don't know. So these are also important, especially if you are filing a bail application where the FIR was, you are not a named person as far as FIR is concerned. The Supreme Court has many a time said that FIR is not an encyclopedia, but at least the major important points should always come as in an FIR. So this is why it is important that you rely upon your FIR to see the discrepancies that may have occurred. So, for instance, if you are not named in an FIR, then one would imagine that probably your addition of your name or your name coming in is an afterthought, and it is not linked to the crime. Then they typically also ask if there is a reason for delay in reporting of the information or complaint. They will always ask if there is a reason. If there is no delay, that is fine. So next, if you can scroll down a bit.
Yes, yes,
yes.
Is it
Point 9 onwards.
Point
Now,
9, okay.
point 9 is about typically if there is something which has been stolen, then you will find that this is the thing that was stolen. That could be mentioned. You will see 498 cases that the woman will write down hundreds of items, and these hundreds of items were stolen by my mother-in-law or by my husband, etc. Or so many times you will see that the husband may have put that accusation on the wife, saying that, okay, my wife actually stole all the family jewelries and went. So this is just an instance. It is not really, all the cases are not like this. Then if it is a theft case, then it will always be, the value of the property will be given. And then inquest report is when you have, a case of, for instance, 302 case or a 307 case, then you will find an inquest report there. Then is the FIR contents. Typically, the FIR contents, the entire FIR then gets written over there. That, okay, to the station house officer, etc. And then the entire story gets written as far as the FIR contents is concerned. So can you go down on this?
Yes, ma'am.
So this you will see is a story which is given in the FIR, which is then replicated in other places. So you'll have to go